Well, it is 12 o'clock, so we're going to go ahead and get started. Just before we dive in, a couple of housekeeping announcements. We are recording this session, so we ask that all attendees please keep your microphones muted and your cameras off. This helps us get the best quality recording. We have applied for CLE credit for this session. I believe it is pending. We will put that in the chat here shortly. If you have questions during the session, please enter them in the chat. We will have time for questions at the end of the session, and we will relay those via the chat to our presenters. With that, I'm delighted to turn it over to our two speakers today, Marshall Tannick and A.L. Brown. They are going to introduce themselves and dive into the material, so I'm going to go ahead and turn it over to them.
Thank you very much, Sarah. This is Marshall Tannick. I'm happy to be here and pleased to have this opportunity to talk about an interesting issue with a provocative title and a very timely title, Slavery in Minnesota. Yes, it happened here too, and we're very timely to do this right in and around the Juneteenth period of time, commemorating Juneteenth. My co-presenter is A.L. Brown. I will let A.L. briefly describe and introduce himself, but I will describe him as a prominent St. Paul attorney who helped me put together these materials and offered some interesting perspectives, and probably should have his name on the cover too. A.L., what do you have to say for yourself?
Well, thank you, Marshall. I'm A.L. Brown. I'm an attorney here in St. Paul, practicing in both criminal and civil work, primarily plaintiff's work, and on the civil side, and defense work on the criminal side, both in state court and appellate courts. State court and federal courts, trial courts and appellate courts. Marshall's going to take the lead on this for the most part and give us a good overview of the history. And then I think we'll have a good conversation about the Dred Scott decision itself with what I think is a thoughtful perspective. And then we'll have a conversation again about slavery and come back to a discussion about reparations. And so I hope you enjoy it, and I'll get out of the way. Go ahead, Marshall.
Thank you very much, A.L. I'm Marshall Tannick. I'm with the law firm of Meyer News Tannick in downtown Minneapolis. We also have offices in St. Paul and St. Louis Park. My topic today is the history of, quote, slavery, unquote, and race relations in Minnesota, but looked at through a legal perspective. We'll go to the table of contents and see what we have coming up now on the next slide. This is what we're going to talk about. We're going to veer a little bit from this, but this is just an overview. We're going to talk a little bit about the history of slavery here in Minnesota, leading up to the infamous Dred Scott decision, how that was affected by and affected Minnesota law, some post-Civil War developments, and get into modern times with some various legal issues concerning race relations and educational enigmas as well. So let's move on to the beginning here and start off historically with what I refer to as the boundaries of slavery. And we're going back now a good 250 years nearly with the Northwest Ordinance. The Northwest Ordinance was a law adopted in the early years of the country. Actually, the Constitution, as you know, wasn't adopted until ratified until 1787. So it's right in that time period where we're becoming a constitutional democracy or republic. And it's set up, the Northwest Ordinance basically provided for the governance mechanisms and procedures in the Northwest Territories, which in those days were the territories essentially west of the Appalachians, stretching out as far as the United States owned. At that time, the Ohio Basin Valley was pretty much as far west as the country went, but the ordinance created a process to admit new states in west of the Appalachian Mountains, as well as provided a Bill of Rights for people living in the burgeoning territories. The Missouri Compromise was 33 years later. The Missouri Compromise was enacted by Congress, and it was really the first rumblings of what was going to happen 40 years later with the Civil War. The problems with dealing with slavery and the regional and sectional interests came to a head in 1820 in terms of admitting new states. The concern in the southern states, the slaveholding states, is that they were going to be outnumbered, and therefore they wanted some kind of parity or equanimity in terms of slave states and free states. The Missouri Compromise set up an arrangement that was carried out for a number of years thereafter, which essentially was a trade-off, 1-for-1. Missouri was brought into the country as a slave state, although Missouri did not participate in the Confederacy during the Civil War. It was a border state. But Missouri was designated as a slave state, in other words, a state in which slavery could be legal. And Maine came in as a, quote, free state, a trade-off to keep the balance of power equivalent between free states and slave states. The Missouri Compromise also significantly prohibited slavery above the 3630 parallel. That referred to the land that was purchased in the Louisiana Purchase. 1803, the United States bought basically the territory extending from Louisiana in the south all the way west to about northwest through certainly the central part of the country and west toward to encompass the area up until the Rocky Mountains. So that area between Louisiana going straight north and going west towards the Rocky Mountains was essentially purchased from Napoleon, who wanted the money to fund his various wars that are going on in Europe, especially his battles with the British. We bought that territory, which was largely uninhabited at the time. And as part of the Missouri Compromise in 1820, slavery was prohibited essentially north of a line extending from Missouri to the East Coast. So if you draw kind of a straight line from the top of Missouri or the south of where Iowa is now, a straight line from the border between Missouri and Iowa extended to the extended in both directions, really, east and west. Slavery was prohibited north of that. It's a version of the Mason-Dixon line, which was a little bit different, but north of that, to the north, no slavery in any of the new territories. This area was largely uninhabited, and there were no states, very few states in that area, but to the extent that new states would come into the Union after 1820, if they were to the north of Missouri, they'd be free states. If they were south, they could be slave states. Let's go to the next slide here and see what that leads to. Well, Minnesota, of course, back then was uninhabited largely, except by Native Americans. We had Fort Snelling in 1820, which was the year of the Missouri Compromise, but otherwise there was no inhabitants here. But as settlers came into the area in Minnesota, the territories became inhabited, really going from east to west, Wisconsin before Minnesota. But Minnesota was still at one point an uninhabited territory. But in 1849, Minnesota became a territory of the United States. It had a territorial government, territorial governor, and all the accoutrements of a state, but it wasn't a state yet. Wisconsin was, Minnesota wasn't yet. At that time, in the 1840s and 1850s, Minnesota became a haven for Southerners vacationing here at St. Anthony Falls to get away from the brutal weather conditions in the South of that time. So Minnesota, along the St. Anthony Falls, right where St. Anthony, Maine area is now, just outside of downtown Minneapolis, became a haven for many wealthy Southerners vacationing here in the summer. And as they did, they would bring their slaves with them. They'd bring their whole households with them and lived in, for the summer at least, vacationed on the Mississippi, on the St. Anthony, Maine. One of the major facilities there was called the Winslow House. It was a resort right on the Mississippi in St. Anthony, Maine, and that's where many of the wealthy Southerners vacationing here stayed along with their slaves. There is a facility there now, an elite type, high-priced condominium building called the Winslow House, and that's on the same territory, that tall high-rise above St. Anthony, Maine. That is the territory, that's the exact place where the Winslow House Resort for Southerners and their slaves existed back in the 1840s and 1850s. At that time, Minnesota had its first slavery-related case. The case was called Eliza Winston, not to be confused with Winslow. Winslow is the name of the resort. Eliza Winston was a slave who was brought here to Minnesota with her masters in the summer while they were vacationing here. He escaped across the Mississippi and went to St. Paul. St. Paul was more established at that time than Minneapolis was, but she went to St. Paul or Ramsey County as an escaped slave. A number of residents there took her in, and as she escaped. Her master then went after her under the Fugitive Slave Act, which you're familiar with, which was a federal law at the time and in the federal constitution, which allowed individuals to be basically deputized to go after any escaped slaves or alleged slaves. So her master deputized some people, and they went after her, and ultimately it ended up in the Ramsey County court system. And the Ramsey County court had to decide whether Winston was or was not to be returned to her master. The court ruled in favor of Winston and said because she escaped and because Minnesota was at that time a free territory north of the 36th parallel, that she was entitled to be free, and she was. She ultimately, they appealed, the master appealed that case to the Minnesota through the Minnesota appellate court system, but by that time she had gone to Canada and on the Underground Railroad, and it was too late, and she got her freedom. That was a predicate for the Dred Scott case. And in the 1850s, there were about a dozen blacks living in Minnesota, according to the census. The Minnesota was admitted as a state in 1858, and the Minnesota Constitution, Article 1, Section 2, specifically said that there shall be, quote, no slavery or involuntary servitude in Minnesota. That incidentally was the same language that ultimately was used in the 13th Amendment, the post-Civil War Amendment, abolishing slavery. By 1860, there were 259 blacks in Minnesota, according to the census, out of 172,000 people. That they were about 1/4 of 1% of the population of Minnesota was African Americans or blacks at that time, and very few in the Twin Cities. Most of them were in the northern part of the state, working in lumber areas or fur traders. So the black population, such as it was at that time, was not heavily concentrated in the Twin Cities. It was spread out in the state and more in the northern part of the state. By the time the Civil War started, Minnesota contributed 259 blacks to the Union Army. 259 of the 25,000 soldiers and seamen and other people, militia from Minnesota, were blacks. 259 of the 25,000. Next slide, please. Can we get to the next slide? And that leads up to the Dred Scott decision. The technical name of the official name of the case was Dred Scott versus Sanford, 1857. It's kind of a convoluted procedural history to the Dred Scott case. It bounced through many different state and federal courts in the central part of the United States over a period of about 10 years. It ultimately came before the Supreme Court in 1856. The decision was rendered in 1857. Dred Scott was enslaved to a military doctor and who was for a time period, for 2 years, stationed at Fort Snelling, right out there in Bloomington, right next to where the international airport is now. Scott lived in the basement of the infirmary, which is still on the site, the actual living space of Dred Scott and his family. He was married. He had a wife, Harriet, who also was a slave, and 2 daughters. They lived in the basement of the hospital or infirmary on the campus of Fort Snelling, and they were servicing the doctor who worked at Fort Snelling. Scott brought a lawsuit, and as I said, the lawsuit extended for about 10 years. He was here in Minnesota for only 2 years, but he sued, ultimately seeking his freedom because he claimed that because he had lived in Minnesota and he had been a short time in Wisconsin as well. Just a minute, I'm going to close the noise in the background. Sorry about that. He had also lived for a short period of time in Wisconsin, but mainly in Minnesota. He claimed that under the Missouri Compromise of 1820, he is entitled to be free because he lived in free territory. And the Missouri Compromise, federal law, said that anybody above the 36th parallel, above the north of Missouri, is free. That was the genesis of the Dred Scott case. The case was decided on March 6, 1857, but it was leaked. The Supreme Court decision was leaked to James Buchanan, who was the incoming president, who ran on kind of a laissez-faire campaign. He was not against slavery. He was a Northerner, but he was not opposed to slavery at the time. In his inaugural address, March 4th, 1857, Buchanan referenced, he didn't specifically say it, but he referenced the fact that the Supreme Court was about to decide this important case. And he indicated that he thought that that would, quote, bring the matter to a final resolution, unquote. 2 days later, the Supreme Court did issue its decision, and it didn't bring this to a final resolution, it brought it to a bloody resolution. The Supreme Court holding in the Dred Scott case was multiple. First of all, the Supreme Court said that black people have no rights warranting, quote, respect, unquote. Slaves are property, not persons. Because they're persons, because they're not persons, they're property, they belong to their owners, and they have no rights. Furthermore, the court went on to say that since slavery is a matter of property, no legislation can take away a person's property, and therefore, to the extent that the Missouri Compromise purports to bar slavery in north of the 36th parallel, north of that latitude, it's unconstitutional. Slavery cannot be barred, the Supreme Court held, in any part of the country unless the state wants to. And many states like Minnesota, which came into statehood a year later, many states prohibited slavery in the state constitution, and the Supreme Court said, well, that's okay if you want to do that, but you can't bar it. You can't bar slavery under the federal constitution in the new territories that are emerging, which is most of the rest of the Midwest and the central part of the country and the west part of the country. The court was kind of relying on the concept of popular sovereignty. That was a concept in the Kansas-Nebraska Act in 1854, which basically said that each state can make its own decisions as to slavery or not slavery in their own constitutions, as Minnesota did. But the Dred Scott case holds that the federal government can't bar slavery in areas owned by the federal government, which is the vast territories that had not yet become states. Many critics have referred to the Dred Scott case as the worst decision ever by the Supreme Court. It's been called a self-inflicted wound, and it led to what William Seward, who became Lincoln's Secretary of State, but at the time was a leading candidate for president at the time in 1860s, and brought about an irrepressible conflict. And in fact, it did lay the foundation for the Civil War. It also prompted a one-term congressman from Illinois who had served one term in Congress in the late 1840s, and then he returned to his private law practice. It inspired him to get back into politics. His name was Abraham Lincoln, and he has said specifically that it was the Dred Scott decision that prompted him to return to the political scene and led him to the famous Lincoln-Douglas debates, and the rest is history. So that's how the Dred Scott case plays in historically and legally, and here from Minnesota. My question to you, AL, is clearly the Dred Scott case was a self-inflicted wound and a terrible decision and an immoral decision, but was it an illegal decision? Was it unlawful at the time? Or put another way, given the existing law at the time, could one make an argument, as some did, that the Dred Scott decision was legally sound, if not morally bankrupt?
Thanks, Marshall. I think that's an important question to ask, and I want to approach it from give a little bit more background to Dred Scott in the sense of who the decision makers were. You had Chief Justice Taney, who at the time was 80 years old. And so we're not talking about a man who is particularly young and waiting on life to illuminate him on the savageries of slavery. The decision was of major consequence, and that's obvious by the fact that it was argued twice at the U.S. Supreme Court because the court was concerned about rushing the decision. They wanted to lay it over to see if they could get some sense of a unanimous opinion. And in fact, in one of the concurring opinions, it kind of notes that they regret that they could not get a unanimous opinion. There were, of course, two dissents to that, and I'll talk about it briefly. The dissents to the decision, which I think in some part help answer Marshall's question as to whether it was legally sound. For those of you who are attorneys, and I'm not going to assume that everyone is, so I'll offer what to you what I consider to be a reasonable definition of originalism and why it matters in its connection to the Dred Scott case, and ultimately to Marshall's question about whether it was rightfully decided. I think originalism, which is generally supported by those in American politics and judiciary, we would say are on the right, is a form of understanding the Constitution, both from its text, but understanding the text of the Constitution in the context of what the founders understood it to mean at the time. And that really undergirds the decision of the Dred Scott case, because what the court did, Chief Justice Taney did, was he looked at the history of what is referred to as the Negro, referred to as the slave. I prefer enslaved people as an acknowledgement of the humanity of these people, not putting the bondages of commercialism that was insinuated into their humanity at the forefront of the discussion. And I think the dissent in that decision refers to them as human beings, which just really shows you the difference between how these two jurists approached it. So originalism would be understanding what the founders understood the Constitution to mean and cabineting your understanding of that, the understanding of the Constitution to that point in history. And so when you go through the Dred Scott decision, you see quite a bit of historical analysis, and Marshall talked about some of them. But I want to read to you some of the passages from the case so you can really get a sense of what the issue was. And the court put it quite starkly. The question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights, privileges, and immunities guaranteed by that instrument to that citizen? In other words, if you want to use more modern language, do Black Lives Matter in the context of the Constitution? Were they citizens? Could Dred Scott sue? We know the answer to that is that the court ultimately decided no, but what I'm more interested in is how the court got there and whether originalism is a legitimate means of understanding the Constitution today, or is it a form of judicial interpretation, constitutional interpretation, that perpetuates the white supremacy that was evident in the Constitution that led to the Dred Scott decision. And so I think if you read through the Dred Scott decision, and maybe many of you have not done it since law school and maybe have found no need to do so, but it is a fascinating read. And it reads much like the modern opinions of today's, particularly conservative court, on the issue of originalism. If you look back at originalism, if you look back at the state of the country as it existed at the founding of this country, I think there is a intellectual argument that the Dred Scott decision, although morally reprehensible, was legally correct. They answered the question, the simple question, by looking at history, by looking at the state of people who were enslaved at the time of the founding of the Constitution, and they concluded this. And let me give you just, it's a bit of a big paragraph, but I think it's worth it. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty, and who hold the power and conduct government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and is a constituent member of this sovereignty. The question before us is whether the persons of class described in this plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not, and this is the historical aspect of it. and were not intended to be included under the word citizen in the Constitution, and can therefore claim none of the rights and privileges which the instrument provides for and secures to the citizens of the United States. On the contrary, they were at the time considered to be subordinate and inferior class of beings who have been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those held by the power of the government might choose to grant them. And so let me kind of sharpen this here as to what my primary point is. My primary point is using history as a way of understanding the Constitution might be one of the most dangerous means of perpetuating the white supremacy that is inherent in the Constitution. And what Chief Justice Taney did and six of his colleagues, it was they looked at the history of the country and said, yeah, we never counted Black people as human beings, and therefore they do not have the right. Now, the flip side of that is there is a dissent, particularly the second dissent, which looks at that exact same history and reaches the opposite conclusion. These are men of the same era, men close to the founding of the Constitution. I think Justice Taney was born before the country, with a clear sense of what the common law was in the states and in the England, where they adopted the common law, and reached two separate conclusions looking at the same history. So the question I'll pose to you, Marshall, is it a good idea to use history as a means of determining rights, both as a means of constitutional interpretation or as a statement of what is moral? In other words, do we use history to justify or to explain the immoralities that persist? That's my question.
And that issue came starkly up in two decisions of the Supreme Court last year, decided within 48 hours of each other, right at the end of the term. One, of course, is the Dobbs case, Dobbs versus Jackson Women's Health, the case that struck down the constitutional right to an abortion. And in that case, in the 98 pages by Justice Alito, he spends most of his time analyzing the history of abortion and abortion laws going back to the 14th century, and reaches certain conclusions based on history, which obviously the dissenting group viewed some of the same history and saw it differently, or saw different history. Sometimes it's not a matter of just looking at the same history from two different perspectives. It's a matter of saying, well, what is the history here? And you may have two different versions of history, right?
Well, that's a good point, Marshall. And I'll add this. What do those two groups have in common? Both what the Dred Scott decision refers to as the Negro, and the decision written by Justice Alito. With all of this distance of time between these two decisions, they have the rights of two groups of people who were not considered by the Constitution. I mean, women certainly didn't have the right to vote at the founding of the Constitution, no right to own property. They weren't considered independent individuals. And so to use use history as a means of judging the rights when not only have the social norms changed, and we have observed and accepted that what happened historically was atrocious and morally unacceptable, to continue to use that as a means of understanding rights, I think is a real problem and perpetuates some of the issues.
Another use of historical analysis was done by Justice Thomas in his decision a couple of days prior to the Dobbs decision, and that was in the New York rifle and gun case, in which the court invalidated a New York gun permit and licensing law. And that case turned solely and expressly on the, quote, historical traditions, unquote, of the country in dealing with gun regulation and gun laws. And it paralleled in many respects and used some of the same wording as Justice Alito did in the Dobbs decision in looking at that matter, that issue, gun safety, gun regulations, solely from through a historical prism. And indeed, there have been cases since then, including one here in Minnesota, in which the federal courts dutifully have followed that directive to take a look in Second Amendment cases solely and exclusively as a, quote, historical matter, unquote, irrespective of modern contemporary considerations, or in other words, the living Constitution be damned, right, AL?
Yeah, and so let me show you the danger in that. What happens if, and then we have more ground to cover, but what happens when you get the history wrong? And here's a modern example. And I won't go too far into Section 1983 law, but there is some connection. It was a law passed in order to ensure that the states could not just ignore the 13th, 14th, and 15th Amendments. And it was I think the original name of it was the Ku Klux Klan Act. That law, the Supreme Court has decimated in many ways with this doctrine of qualified immunity, which it took from history. It says it existed not as a matter of statutory law, but existed as a matter of common law and a matter of history. And there's a 10th Circuit decision I'm happy to share with anyone who wants to take a look at it, with a prominent conservative jurist who has identified or repeating the work of a law review article that says that actually they got the history wrong as to the statute, that the Congress at the time intended to overlook or to strip away the common law doctrine of qualified immunity. But we've been living with this decision for decades now, and we'll see what the Supreme Court does with that. But my point in bringing that up is to say that when you use history as a basis, not only do you perpetuate the discriminations that existed at the time, if you establish rights based on a time period, then Black lives will never matter and women will never have any autonomy to their bodies. That's one point. And the other point is sometimes you get it wrong. Sometimes you just get it wrong. And then what do you do in those instances?
Well, speaking of history, let's move back to the Civil War era and trace forward some of the legal issues involving race relations here in Minnesota on the next slide. After the next slide, please. Post-Civil War developments, actually during the Civil War and thereafter, they had the Emancipation Proclamation issued by President Lincoln. He issued it in September of 1862 after the modestly successful victory of the Union forces at Antietam, which was the first major Union victory, although it came at a dear cost of 30,000 casualties. But Lincoln in September said that if the South continues to adhere to its position and the Confederacy doesn't relent, he would, on January 1st, 1863, issue his Emancipation Proclamation. The Confederacy didn't, and he did. On January 1st, 1863, Lincoln signed the Emancipation Proclamation, which I think, as many people recognize, did not, quote, free the slaves, unquote, throughout the country. It was a military directive, an executive order, but it was a directive from Lincoln to the military that all people living in conquered territories, Union conquered territories, all people living in territories that the Union Army controlled were to be free and as he said, forevermore. So what that did is treat the enslaved people as property still, and they were treated as property that was engaged as a bounty of war, and Lincoln treated it that way. One critic, one observer has referred to the Emancipation Proclamation as equivalent to a bill of, it has all the moral imperative of reading a bill of lading. And it has that ring to it. If you read the Emancipation Proclamation, describes the particular territories by latitude and longitude and territorial areas and logistics of where freedom would reign. It didn't affect slavery in any of the areas that were still being battled and contested during the Civil War. But nevertheless, it was a major predicate for removal of slavery. Lincoln felt at the time that he did not have the constitutional authority because of Dred Scott to, quote, free the slaves, unquote, throughout the country. He did, as a commander-in-chief, feel that he had the authority to free slaves in those areas that the Union Army controlled in order to advance the military interests of the Union Army. The post-Civil War amendments that people are familiar with, of course, were the 13th, 14th, and 15th. The 13th abolished slavery using the same language as the 1858 Minnesota Constitution. The 14th Amendment was the Due Process, Equal Protection, Privileges, and Immunities Clause. clauses. And also, as many are aware, also the 14th Amendment contained a provision barring any person who was aided or abetted or been engaged in an insurrection against the United States from ever holding federal office. That's in the 14th Amendment, and obviously has been a subject of some discussion in connection with recent developments. The 14th Amendment, the 14th Amendment is a due process clause, equal protection. Those came right in the throes of the Civil War. The 15th Amendment, the right to vote irrespective of race, did not come into the Constitution until 1870. So there was a 5-year gap between the end of the Civil War and the establishment of the right to vote as a matter of federal constitutional law. In the meantime, a number of states addressed the issue of whether blacks could vote or not in the aftermath of the Civil War, recognizing that it wasn't until 1870 that the 15th Amendment was adopted. That measure was presented in Minnesota twice. It was defeated here 2 times in the late 1860s. A state constitutional amendment to allow blacks to vote, or to really remove any racial barriers against voting, was defeated here twice. Initially, there was a pretty close vote of 1,500 votes. Both times, essentially, it was about 1,500 votes against that. So many of the Constitution allow blacks to vote. And similarly, in 6 other states at that time, they defeated state constitutional amendments to allow blacks to vote, including neighboring Wisconsin. The inability of the states to successfully amend their constitutions to allow blacks to vote was a major, including Minnesota, where it was defeated twice, was a major impetus for the federal government, therefore, to say, well, since the states are not handling this, we're going to adopt the 15th Amendment, which had to be ratified by the states, of course. But the fact that Minnesota twice defeated the right to vote, and some other states did too, underlied the 15th Amendment, which guaranteed the right, at least on paper, the right to vote under the federal Constitution. By 1870, there were 750 blacks, known as, quote, colored, unquote, in Minnesota, according to the census, tripled since 1860. Minnesota passed in 1885 the Equal Accommodations Act. This was a state law, Minnesota state law, first of its kind in the country, which basically said that public accommodations cannot discriminate based on race. Sounds pretty familiar, doesn't it? That was the basis of the 1964 Federal Civil Rights Act. Minnesota had on its books since 1885 a public accommodations provision that ultimately became a template for the Federal Civil Rights Act. Minnesota also had an anti-lynching law in 1921, shortly after the infamous Duluth lynching of 3 carnival workers on pumped up, no pun intended, on rigged charges of sexual assaulting a young woman in Duluth. They were lynched, as you know, in 1919, and Minnesota passed a mini anti-lynching law in 1921. That it was, again, the only state that had a law like that in its books. The federal government resisted any kind of laws like that, and Franklin Roosevelt himself was importuned by many of his supporters to get out in front and try to adopt an anti-lynching law in the 1930s, but he resisted that because of the strong presence of the Democratic Party and his need for the Democratic Party support, which at that time was a segregationist party throughout the South. So the federal lynching law did not come into effect until 2022, a century after Minnesota had its own anti-lynching law. Although the Minnesota law, I might add, was quite tepid and provided for a fine for law enforcement officials who participated in the lynching. It didn't really bar lynching. It just said if anyone participates in lynching, they're subject to being fined and losing their jobs. Minnesota also had early legislation against the restrictive covenants and deeds. In 1948, in 1948, the Supreme Court in the Kramer versus Shelley case ruled that these restrictive covenants, essentially barring sale of property to people based on race or religion, mostly directed to blacks and Jews, was unenforceable, but nevertheless not illegal. Just the courts were admonished that they couldn't enforce those clauses. The 1968 Federal Housing Act prohibited restrictive or racially discriminatory covenants and deeds and purchase agreements. However, Minnesota got there first. 1919, Minnesota had its own law on the books prohibiting restrictive covenants and restrictive deeds. That law was largely ignored or disregarded, never enforced. And as we all know, those restrictive covenants continued well into the 1960s, and now, and as a result of the just deed statute in Minnesota a few years ago, those deeds can be corrected and rectified and modified. But nonetheless, Minnesota had the law in its book since 1919, prohibiting the very kind of deeds that proliferated for the decades to come. Minnesota also was out in front with the Human Rights Act well before the federal Human Rights Act, before the federal Civil Rights Act was adopted as well. So those are some of the ways that Minnesota, I won't say made amends for the Dred Scott decision, but certainly addressed racial relations and legal issues relating to racial relations in a way that was much more advanced and much more in the vanguard than many other states. And in most of these instances I've referred to, Minnesota was the first to enact these kind of laws, and they sat there pretty much unused on the books until a century or so later that the federal government, the federal law conformed with Minnesota state law. Conform with Minnesota state law, which kind of raises another topic I'd like AL to weigh in on, and that's the contemporary topic of reparations. We're seeing, there's been a lot of talk about reparations lately, but now we're actually seeing some action being taken. In California, as many of you are aware of, there's actual proposed legislation at local and state levels to provide for reparation compensation for descendants of enslaved people. The Bush Foundation here in Minnesota announced last week that it was starting its own private reparations program. And we're seeing the issue of reparation, which has been discussed for a number of years, now actually coming into taking fruition in certain forms and formats. AL, do you want to weigh in a little bit on some of the legal problems, issues, I should say, with reparations, and of course, some of the practical problems? We obviously could spend the rest of the afternoon talking about the issue, but you've got about 5 minutes to address reparations, AL, so go for it.
Well, let's see what we can do. I think the primary legal barrier to meaningful conversations about reparations is the public's general view that the law should be colorblind. And I think that evolves from the important work of the civil rights movement and the misconstruing of some of Dr. King's work as it relates to his speech about the content of character versus the color of skin. There is a belief, I think, that to pay some people money based on the color of their skin and not others is inherently racist. And with that history from the 60s and that experience from the 60s, they might conclude that racism or making a distinction based on race is the same as racism. And I think that's one of the problems. The 13th, 14th, and 15th Amendments were about race. A civil war that gave birth to those amendments, I think, Marshall, as you've explained, was in large part about slavery. And slavery, as you can read from the Dred Scott decision, was a particular blight imposed by white Americans on Black Americans. And so I think if you want to move the needle on a discussion about reparations, you have to change the discussion about the legality of doing things that aren't race neutral. And we'll see that come up in the Supreme Court decision that we're expecting on affirmative action. That is, we're expecting this term. Justice O'Connor, when she wrote the last decision, said, in 25 years, we hope not to have to worry about this. I think that was the Bakke decision. But here we are, we're still worried about it, and we're still working with it. So I think we have to first get past the notion that the idea of giving a government benefit to one group of people based on their race is the same as racism. In other words, reparations is an acknowledgement, to my mind, of just an absolute trauma visited upon, that's just I can't think of the right word to capture the effect of not only slavery, but Jim Crow and all those things that followed, which is the other thing we should note. As you noted, Marshall, about the restrictive deeds, that's 1919. That's not 1900. That's not 1850. That's 1919. And 1948, the Kramer decision became necessary. And the same in 1967 with the Human Rights Act. These were all advances made at the push and pull of racism in this country. So reparations brings with it some difficult topics, and we won't get a chance to cover them all here, but to who is entitled to reparations and who must pay. Let me offer this. I think particularly, this is my view. I'm happy to be challenged on it. One of the other things that makes it difficult about reparations is the argument that I had nothing to do with it or I wasn't involved in it, and nor were you, Mr. Brown. I mean, you weren't a slave, and neither were your parents. All true, but that ignores the structural benefit that inures to white populations and the structural deficit that inures to Black population that has never been corrected. And that's what reparations is seeking to fix. It's not only seeking to compensate for labor unpaid for savagery visited upon the people, but also it is there to close that gap between the opportunities that were afforded to whites by virtue of their skin and the opportunities denied to Blacks by virtue of theirs. I will admit to you, in all candor, there was a time in my life where I thought reparations itself was a joke, that that folk need not look back in the past, and that individual white people living on the planet today had nothing to do with. But as I have lived, I have learned, and I have better understood the structural deficits that need to be repaired. And reparations, I think, can come in a number of forms. But I think the time of being dismissive of the conversation should be long past us, and we should all engage. What do you think, Marshall?
Well, I'm not here to promote or endorse reparations or to oppose it, but your comment about the notion that reparations was a joke and how it was treated so dismissively kind of parallels the LGBTQ community's issues. Back in the 1960s and even into the early 1970s, and even beyond that, the notion of gay marriage was considered a joke, and indeed was dismissive, literally and figuratively. As most people are aware, the first gay same-sex marriage case was from Minnesota, Baker versus Nelson, and the Minnesota Supreme Court ruled that same-sex marriage was unconscionable and impermissible, quoting the Bible, by the way. And when that case reached the Supreme Court in 1972, an appeal of the Minnesota Supreme Court decision, quoting the Bible, against gay marriage, the Supreme Court dismissed it literally for want of a federal question. So the court were treating that issue dismissively, and we all know the history of that. And public opinion, too, treated it as a joke and dismissively for many, many years, including many liberal politicians, or at least Democratic politicians. Bill Clinton was against gay marriage. Paul Wellstone was against gay marriage. Barack Obama was against gay marriage. But attitudes change and public opinion shifts. And whereas now 70% of the public supports the concept of same-sex marriage, if you go back 30 or 40 years ago, that probably was 10% or less. Same could happen with reparations. Initially it was talked about as kind of a joke, and hey, why should I pay someone else for something I didn't do? But now it's being taken seriously, and obviously there are some very serious practical and legal problems in working out whether reparations should occur or not. But it's kind of had a trajectory somewhat like the gay rights movement in certain respects. And
well, let me ask you this, Marshall, with the just a flat legal question as it relates to both Dred Scott, the 13th, 14th, 15th Amendment, race issues, and so forth. Is the law better race neutral, or is the law better race conscious, or is it situational?
Well, I don't know if I can answer the better or not, but I can say that that's a good segue to talk about the affirmative action cases, because I guess we're going to find out very soon, within days, how the Supreme Court views that issue. As AL alluded to, and most people are aware of, there are two major affirmative action cases pending before the Supreme Court. One is from Harvard University, and one is from the University of North Carolina. In both of those cases, two lower federal courts and a lower state court and state Supreme Court all ruled in favor of those affirmative action programs. The Supreme Court now is poised to overturn those rulings, and observers and savants and pundits all predict that it's going to be the ruling is going to be against those affirmative action programs. The question, I guess, that's in many people's mind is how much against it is it going to be, what the reasoning of the court is going to be when it issues that decision, which they'll probably issue on the last day of their term, and what the impact might be, not just in academia, where the affirmative action litigation is taking place, but whether striking down or significantly maiming the concept of affirmative action will have effects on other types of affirmative action programs, such as diversity, equity, and inclusion in the workplace and related issues. And it very well may be that the Supreme Court decision, which is anticipated to strike down or significantly impair affirmative action in college admissions, will have repercussions on other types of affirmative action programs in the workplace or elsewhere. And I think that's really important to watch for in these upcoming decisions. There'll probably be a consolidated decision of the Harvard and North Carolina case. Here in Minnesota, we have some contemporary issues regarding racial issues in education, and we'll see that in the next slide as we just move toward wrapping up. We do want to leave. Go to the next slide, please. I just want to touch upon this. Some educational enigmas exist here in Minnesota. The state constitution provides for what's called an adequate education. The term adequate education isn't used in the state constitution, but that's a term that's been used to describe the Minnesota constitutional provision requiring general and uniform system of public schools. The current litigation that's addressing that issue is the Cruz-Guzman case. It's been around for a long time, since 2015, and it's been up and down so many times, I've kind of lost track of it. But right now, I think it's pending before the Supreme Court. Certain features of that case, whether there has to be a proof of intent or not, is the issue now before the Supreme Court. But basically, that case is seeking to establish either different protocols or different school boundaries or just monetary relief, a form of reparations, to deal with what is deemed to be inadequate education in the inner cities in Minneapolis and St. Paul, which turns largely on racial and ethnic considerations. Any thoughts about that, AL?
Well, I think it is at the Minnesota Supreme Court, if I remember correctly. I believe they've heard all arguments. I could be wrong on that. I think it is still pending. That's just another kind of vestige of the structural deficits associated with race, and a form of reparations could include educational benefits. I think we will see from the U.S. Supreme Court a decision on the affirmative action. I want to leave just a little time for questions, Marshall, but I'll offer you this last thought and I'll shut up here. I think that the U.S. Supreme Court will issue a decision that will give comfort, particularly on the affirmative action cases, that will have a very palatable surface. That is to say, what we're saying is we're no longer going to consider race. You finally got what you wanted. Race is no longer an issue. We're not going to consider it. And I think we are headed toward a space in the legal world where there'll be pushback on that notion. And we saw it from Justice Ketanji Jackson Brown's first day on the court, this notion that race is not something that the law not only should consider, must consider. In fact, I'll bring up one last a Minnesotan, I believe it was, help me, Marshall, Chief Justice Berger.
Warren Berger, yeah.
Berger,
Berger.
One of the Minnesota twins, who said in a dissenting decision, when it comes to law, we have to consider race. We can't ignore it. And I think that may be against the prevailing winds on the conservative side of the court now, but it is nonetheless true. I think we should open it up for questions. We've got 5 minutes. If there's any in the chat, any comments, any thoughts, we're open to hear them.
Okay, Sarah or Scott, or who's ever orchestrating the chat room, what can we do here?
Well, we've had a very robust discussion in the chat. Certainly, I haven't seen any questions directed specifically at the speakers, and I do want to give everyone a chance to add their questions. Regarding the discussion that's already happened, I know our presenters didn't necessarily see that as they were speaking. We will make sure that a copy of that is sent to them after the presentation. And it looks like we do have one question that's just come in here. Given that the current Supreme Court majority through its decisions has proven it is a danger to many people in this country, what are the speaker's opinions on expanding the court size?
Well, okay, I'll weigh in on that very briefly. There is finally legislation that's been put forward in the House by the Democrats. It won't get very far in the House, but there is legislation, at least on the books now, going forward, bill to expand the court to 12. Been talk of expanding it to more people, a larger court as well. President Biden, in the first month of his administration, set up a blue ribbon task force to study the court packing issue, and they spent about a year doing it and came up with, I think it was a 395-page report, but it made no recommendation at all. All they did is kind of trace the history of the size of the court and other issues of court packing back in the Roosevelt days, and came to no conclusion. So the issue kind of died there, and it's kind of it's waned quite a bit. In my judgment, at least as a practical matter, I don't think we're going to see any action on court packing for quite a long time. In terms of whether it's a good idea or not, well, I guess that's debatable. But any kind of, I think that the real challenge to the people who want to change the composition of the court in terms of numbers, it would have to be to come up with some way that it can be done without a constitutional amendment. And there are some ways, and I've suggested some in an article I wrote, that there are ways to address that issue without having to amend the Constitution to take away the lifetime tenure of judges. And that would be much more practical than trying to undertake significant constitutional amendments to essentially expand the court. If there is,
Marshall, you think you'd need a constitutional amendment to expand the court? I don't know that there's anything in the Constitution designating the number of justices on the court.
No, there doesn't have to be a constitutional amendment. That's why I said there was talk about a constitutional amendment. Now the Democrats have come forward with at least a proposal that would do it by legislation. And there's other administrative ways it could be done too. There's nothing in the Constitution that says that the Supreme Court justices have to, that they can't alternate or rotate to different courts, set up different sections of the court, change rotate the Chief Justice. There's a lot of administrative internal things that can be done that are even short of legislation or administrative action. But any kind of significant modification of the lifetime tenure of judges would require a constitutional amendment. So that leaves the only practical alternative is to expand the number of members of the court. And as many people know, that number has been fixed and has been stable at 9 since 1869. But prior to that, during the first almost century of our country's existence, the number of Supreme Court justices varied and vacillated between as little as 3 and up to 9. So there's nothing magic about the 9 other than it's a current law since 1869. It can be changed.
I think we've got 1 more minute. If we want to wrap it up or take another question. Or...
Well, we've got a follow-up on that discussion, whether these proposals would set a troubling precedent. I don't know if you want to address that or.
Yeah, well,
I'm over.
Yeah, well, AL can address. I mean, I think that that's certainly a danger that's been pointed out. That if you do it on this level because of certain feelings about the ideology of the current justices, that might come back to bite you in the behind at some subsequent time, right, AL?
Well, I'm over the dangerous precedent. We're going to get there eventually. This country seems to be dead set on trying every norm to its end, and it is lawful. I mean, I think that's something we have to say. Congress has the right to change the number of members of the court. There's nothing in the Constitution says otherwise. And as Marshall has pointed out, it has moved back and forth. So I'm of the mindset, whether it's on the right or the left, that the public has a right to see your clear vision in action, so that they can make a decision. I take a different view that somehow gridlock is actually helpful. I'm not so sure about that in all things. So that's my take, but it's 1 o'clock.
It is 1 o'clock, and I don't see any more questions in the chat. And as I mentioned, there has been a robust discussion throughout today. Then I'll make sure that both of our speakers get access to a copy of the chat if they're not able to read, haven't been able to keep up with it as it's been going on. And thank you everyone for your comments and your attendance today. Since it is 1 o'clock, we'll go ahead and wrap up here. We can keep this open for just another couple of moments if anybody has any additional questions. The CLE code, I will put that back in the chat. It is still pending as of this morning, but you should be able to add that to your CLE profile, and it will be updated when the session has been approved. So with that, we can wrap up here. I want to thank Marshall Tannick and A.L. Brown for being here today. And thank you everyone for attending.
Thank you.
Thank you for giving us this opportunity to address these important issues, and happy Juneteenth, everyone.
Thank you.